You recently worked on a case that was featured in the Boston Globe and had significant ramifications for victims of domestic violence. Before you talk about that, can you introduce yourselves?
Sure. I'm Melissa Levine-Piro. I'm the owner of Hera Law Group. We're a family law and estate planning firm with offices throughout the Commonwealth of Massachusetts.
And I'm Amanda Castro. I am the managing partner at Hera Law Group, and I also primarily practice family law.
So, what happened in this case?
We just successfully won an appeal of a restraining order that had been denied at the extension hearing. The facts of the case were that our client had applied for a restraining order ex parte, meaning without notice to the other side. She had originally been in a dating relationship that was very abusive with someone throughout college. They had broken up. She hadn't heard from him in a few years. And out of the blue, she received some threatening messages through Instagram. At the extension hearing, which was a two-party hearing, meaning both her and the defendant were present and both parties had attorneys, they both testified. And the judge determined that her fear was palpable, that her testimony was credible, and that the messages she received could be construed as threats. Yet he told the parties that he was going to deny the extension of the restraining order due to the fact that the defendant was a college graduate. This could follow him for the rest of his life, and that he had no criminal charges ever in his past.
Did this case meet the requirements for getting a restraining order?
Really good question. So this case met the standard because our client had been in a dating relationship with the defendant, and it had been a violent relationship at times. She hadn't heard from him in a period of time. And the event that transpired was that she received Instagram messages from him out of the blue, as well as many, many calls in a short period of time. Those Instagram messages contain wording along the lines of, I will be at your house in 15 minutes and I am going to dismantle everything around you. See you there if you're there. Right? So in this case, her fear was reasonable. She was so scared. She called 911, and 911 was the one who sent her to go to court to get a restraining order. It was imminent. He said 15 minutes. It was a concrete, very short period of time. And the threat of harm was reasonable. He said he was going to dismantle everything around her. She took that to be a threat where he was going to hurt her and her family as she lived with her parents and other members of her family.
If this case met the requirements, why did the judge deny it?
Yes, so the judge in this case ended up denying the restraining order because he said that the defendant didn't have a criminal record, and he essentially said that he felt he had learned his lesson and that therefore the restraining order wasn't necessary, which is obviously not the standard in Massachusetts. So this is a circumstance that we do see in a lot of cases, that the trial court does not necessarily follow the standard for granting a restraining order, and they consider outside factors such as the effect of a restraining order on the defendant. This case, however, was a great one for an appeal because the judge very clearly stated on the record that the victim did meet the standard, that her fear was reasonable, and the threat uh, was taken to be imminent. However, the judge stated very specifically that the reason he was denying it was because of the effect that the restraining order would have on him.
You won the appeal. What is the impact of this ruling?
So this ruling was great because it not only helped our client, the case was remanded back for another hearing, but it's going to help future victims of violence who are applying for restraining orders, because there's now clear case law that says that judges cannot consider the effect a restraining order will have on the defendant when deciding whether or not to issue or extend a restraining order.
How did this whole process affect your client?
There were big ramifications for her. Our client lives in fear every day of running into this person, the defendant, her ex-boyfriend. She doesn't go to certain towns, including where he lives, doesn't participate in certain activities for fear she'll run into him. And not having that restraining order in place was really hard for her. People say that restraining orders don't mean much because it's just a piece of paper, but that's actually not true, because if a defendant violates a civil restraining order in Massachusetts, the violations are criminal. So he would be charged criminally. And she really felt protected by that and felt that he respected authority. So it had a lot of teeth to her. Also, while we were successful with the appeal took close to a year. So that was a year almost that she went without a restraining order. So it did have dire effects on her not having this allowed to be extended at the extension hearing.
And what do you recommend somebody do if they are in fear for their safety and they are thinking about getting a restraining order?
So if you are in fear for your safety, first and foremost, you should contact the police department. They have the ability to help you with a restraining order, especially if it's after business hours on an emergency basis. Otherwise, if you're not in immediate danger, but you are in fear or you have been harmed, you should go to your local court and file a restraining order. You should also contact our office or another attorney's office to discuss the process for a restraining order and what your options are. And we would be happy to help you through that process.
And how do you get a restraining order in the state of Massachusetts?
So, in order to get a restraining order, a person first goes to either district court in Massachusetts or probate and family court. They have concurrent jurisdiction. So, either court is okay. It's based on where you or the defendant live. You'll apply for a restraining order, filling out a paper form with an affidavit, go in front of a judge, what we call ex parte, which means only you are there, the other side isn't present, and you'll present your case for why you should have a restraining order. After the judge hears from you and reads your affidavit, they'll decide whether or not to issue that restraining order ex parte. It is usually marked for 10 days later that there'll be a 10-day review hearing to decide whether or not to extend it. So once you get the ex parte order allowed, assuming it is allowed, the defendant is served via the police department and you both return for the extension hearing. So that's what our client did. She returned for the extension hearing and she hired our firm, Hera Law Group, to go with her and represent her at that two-party extension hearing. And that's the hearing where the restraining order was denied and which this appeal stems from.